Ms. Giuliani, in your opinion, should Congress act now or wait for the Supreme Court to decide this issue?
I think that Congress should act now. We don't know when or if the Supreme Court will take this case. It could be 5 years or 10 years. And candidly, in many cases, our legal cases have lagged behind technology. And we're at a point where location information is becoming increasingly more accurate and is being collected by a wide variety of parties. Smart cars, smart medical devices. We're fairly close to having information about our location collected by these third parties. Given this, we believe that Congress can protect the rights of Americans, ensuring that location information is afforded a high level of protection, and do so in a way that is reflective of our current technological realities.
Same question, Mr. Larkin. Should we wait for the Supreme Court to decide this issue, or should we pass legislation?
You should not wait. You should look into the facts and then address the issue. In the Jones case, for example, the beeper was placed on the vehicle in 2005. The Supreme Court didn't decide the case till 2012. You can decide things a lot faster than it took the Supreme Court to resolve that issue. Secondly, whatever you decide, I think, would be well received by the Supreme Court. Justice Alito, for example, in his concurring opinion, almost pleaded with Congress to address this issue and let the cup pass from the Supreme Court. The same thing has happened in all the other cases where Congress has addressed electronic acquisition of information. The Supreme Court has been very deferential, realizing that Congress can balance considerations and has access to data it does not have.
This is a larger question, but I know that Heritage speaks to this question. Doesn't Congress lose power to the other branches when it abdicates its responsibility to legislate on these issues?
It depends on what the particular issue is, but the general answer is yes. If power not used tends to wither, and then when you try to use it later, you have a long line of precedents that people tend to point to say that you no longer have this power, you've passed it on to somebody else.
Right. That's what the late Justice Scalia told me, in fact. Mr. Downing, when we vote on this issue and legislate and amend this legislation, how many of us in the House of Representatives are going to be voting on this?
Sorry, I don't understand your question.
How many members of the House of Representatives are eligible to vote on this issue?
I believe it's 435, is that correct?
That's correct, 435. So why would you share the post-Jones memorandum with only 2? I mean, this ostensibly, whatever we legislate is going to have a profound effect on how you are allowed to interpret these issues. So why wouldn't you want Congress to be informed?
Congressman, we very much do want to have Congress be informed and want to respect the need of this committee to have the information that it legitimately needs to make its decisions. However, there are certain circumstances where particular memos contain information that if it were released publicly, or it would be detrimental to the ability of us to do our jobs. And so we seek to try to find some accommodations to allow for that.
Let me just echo what Mr. Liu said. This breeds mistrust when you don't trust Congress. And we are trusted with many other secrets of national importance. And I think the people's representatives, if not the people, at least the people's representatives, deserve to know how the laws are being interpreted and how they're going to affect them. And I would remind you that there are also 435 of us vote on your budget as well.
Thank you. We have actually done a lot to try to provide and answer any questions that the committee may have as a result of that. We've provided our public positions, which really go through all sorts of the positions that are relevant to these decisions. I've also briefed staff and answered all of their questions. We're really trying very hard to give the information to the committee.
I'd like you to try a little bit harder and give me those post-Jones memorandum. Should it be legal to turn off precise geolocation on a phone? Ms. Giuliani?
You, in fact, cannot turn off precise geolocation on your phone. Under FCC rules, all cell phones must have the ability to have GPS information. The idea of this was to provide the ability for emergency personnel to access you. Yeah. But this information is routinely provided to law enforcement. Based on new regulations that the FCC has put out, they've asked carriers to increase the accuracy of this information so they could be able to assess, what floor of a building you're on.
I remember in the early 2000s I was in the tech industry. I went to a factory to get something manufactured, and they were too busy. They were retooling all the cell towers so that all of your phones could be tracked. And it was under a mandate that presumably Congress issued. And it strikes me, if this data didn't exist, we wouldn't be having this issue, or if a person had the right to turn that off. And you could see how it could easily work with a microcell, where you put this, you plug this element into the internet, and then your cell phone works magically wherever the internet is. But I know that it won't come on until the GPS finds a signal. Because of what we've done here in Congress, you are not allowed as a consumer to make a phone call unless the government is able to find out where you are. And we did all that under the pretext of safety. So, one of the suggestions I would have, Mr. Chairman, is giving some exemption to that law, allowing people to have privacy, because we're saying, well, it's not private when you share it with the third party, yet we're not even allowing you to make the phone call without sharing it with the third party. So with that, I
Thank the gentleman.
thank you. Yield back.